This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why a suit against an insurance company in Louisiana failed because the plaintiff either refused or was unable to comply with the court's case management order, and the plaintiff's and his counsel's sloth resulted in dismissal of his bad faith suit against State Farm. State Farm Fire and Casualty moved the United States District Court to dismiss under Federal Rule of Civil Procedure 41B because the plaintiff failed to comply with the court's case management order, the CMO. In Hensley, Roosevelt versus State Farm Fire and Casualty, the United States District Court for the Western District of Louisiana, on January 10, 2025, resolved the dispute. After plaintiff alleged damage to his home in Hurricane Laura on August 27, 2020, and Hurricane Delta, which impacted the same area on October 9 of 2020, plaintiff, represented by attorney Harry Cantrell, filed suit on October 10, 2022, alleging that his home was insured by State Farm and that State Farm failed to timely or adequately compensate him for his coverage. Due to plaintiff's non-compliance with the court's CMO, the non-responsiveness of plaintiff's counsel, and correspondence indicating that plaintiff intended to enroll new counsel, the court ordered that plaintiff provide a status update and enroll new counsel by September 6, 2024, or risk dismissal for failure to prosecute. New counsel filed a motion to enroll for plaintiff on September 6, but failed to provide a status update. State Farm filed a status report on September 12 detailing plaintiff's failures to participate in mediations under the requirements of the CMO. The following month, it moved to dismiss the suit due to plaintiff's failure to comply with the court's order. Plaintiff failed to provide his disclosures to State Farm by filing them into the record on December 7, 2024, that were not only timely but also woefully incomplete. Plaintiff failed to offer any information that would allow State Farm to compute his outstanding damages, despite his previous representations that he was prepared to proceed. State Farm's records show that it has tendered $166,934 to plaintiff. State Farm then filed a second motion to dismiss, arguing the suit must be dismissed due to plaintiff's inability to follow court orders or proceed under the CMO. Plaintiff has not responded to the motion under the court's deadlines. Federal Rule of Civil Procedure 41B authorizes a district court to dismiss an action for failure to prosecute with or without notice to the parties incident to its inherent powers. Plaintiff repeatedly failed to engage with the court's CMO by filing timely, complete, and accurate initial disclosures. The delays at this point amount to years. Plaintiff made clear now that he is unable to provide State Farm with the information necessary to meaningfully proceed under the CMO or otherwise make good faith attempts at resolving the matter. Plaintiff's inability to gather basic information in support of his claims after months of warning shows that he most likely has nothing to back up his suit. Accordingly, the matter was dismissed as a sanction under Federal Rule of Civil Procedure 41B, and the case was dismissed. In my opinion, some people and their lawyers believe that if they sue an insurance company, it will immediately give up and throw money at the plaintiff to go away in fear of a bad faith punitive award. This case establishes that belief is unfounded. State Farm refused to give up because it was sued, and 2 lawyers retained by the plaintiff failed to follow the rules in the CMO, and the case was dismissed. Sanctions further than a dismissal were appropriate, but not imposed. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll have access to the more than 4,950 blog postings. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.